the estate of June Kemper and legal fees assessed by the town of Waukesha to the estate. You've all seen the notice that's been handed out by the estate, served on the town as well as the law firm of De La Mora and De La Mora. How would you guys like to proceed?
The way I understand it is, this is a possible lawsuit, and that's what we have insurance for. So, Hector, are we correct or not correct that we should not be discussing this at the point this is?
You are correct, and I would recommend that you schedule this matter in closed session, and prior to that you contact the town's insurance carrier for coverage on this issue. I have only forwarded information to you, and I have not been given any direction in this matter, and for that reason, it's before you.
I disagree. You have been given direction in this matter. I have no interest in discussing our blunders in private. This is your issue, Hector. You made a bill of $2,300 for research on ancient roads. I have no idea why we would put this forth to our insurance company. I have no idea why it's before us. I have no idea why you haven't handled this already. That's the direction that you were given was, you created the problem, you fixed it. You fix it. No different than if our town snowplow contractor tore up some property, we expect them to fix it at no cost to us. No different than if one of our paving contractors did some defective work, we expect them to fix it at no cost. This is your problem, not the town's.
Mr. Chairman, I would just refer you to our written correspondence.
Which is what?
You have copies.
No, I'm sorry. My commentary to you is, your problem, you fix it. I didn't create this. Your absurd bills for ancient road research created this issue. Not anything that we did, not anything that I did.
Mr. Chairman?
Yes.
I guess my thought, a couple perspectives. I find it hard to believe that our insurance carrier is going to be interested in getting involved in this. I mean, this is, the fundamental essence of this, from my perspective, is about collecting a bill which I don't think should have ever been sent in the first place. I don't think the town should have been in receipt of that bill, and I don't think it should be, I don't think it's reasonable to expect to pass it along to the applicant in this manner to pay for it. This is a bill collection matter. I can't imagine that our insurance carrier is going to be interested in getting involved in collecting a bill on behalf of the town.
Supervisor Laska?
It's been a practice of our town and our town board, whenever we're threatened with legal issues, that we have our insurance company look at it. It takes some of the politics out of it. They can come back with maybe an unbiased information in that respect. Therefore, I make the motion at this time to go to our insurance company with the necessary information, table this matter, and bring it up at another date.
Table to a date certain or uncertain?
Uncertain.
I
don't think you have. I don't think you have that option, because we are going to be required to respond in a timely manner based on the court's direction.
What is a timely manner? What is the date for a timely manner, please?
Depends on when the court hearing is scheduled. Mr. Butler, please come on up to the microphone, please, if you would, Mr. Butler.
I'm Morgan Butler. I'm a resident of this town. I'm also an attorney, and I'm the attorney for the estate of June Kemper. This matter will be heard by the probate court on November 13th of this year at 1:30 p.m. And the decision, I can never guarantee anything the court will do, but confidence is high, the court will render a decision on this claim. It'll either throw it out, reduce it, or order it paid. Speaking from the standpoint of the estate, you people have sent us a bill which we think is outrageous. For the reasons stated, very clearly stated, if you received the entire notice and motion, it's laid out like a brief.
Question. I'd like to know how it went from 2325 to 28. I've got handwritten 28.
It didn't go to 28. That was a miscommunication between Mr. Butler and I apparently, where I thought there was another $500 there, so it's 23.
Anything else? We'll see you in court.
Thank you, Mr. Butler. There's a motion on the table. Is there a second?
Point of order, I guess. I do not understand the motion because I understood the motion to include a directive and also a motion to table, and I think that's improper. Motion to table is simply that. If it's something else, I don't know what Clerk Salentine's got for the motion, but that's my point of order. It's not a proper motion.
I put to place the date uncertain, but I did not put in any of the verbiage for clarification because tabling, as you have stated, is correct.
So can you
It's just
simply
a table.
read the motion then as you would understand
I
it?
think there was still a discussion if it was a date uncertain or certain.
Supervisor Alaska?
Yes,
A date uncertain or certain? It's your motion.
the November 13th, like Attorney Morgan indicated, can be affected by date certain or date uncertain. So virtually, we're depending on the insurance company to get back to us with some information on this.
No, we're not. Mike, your motion is to table. Is your motion to a date certain or uncertain?
Uncertain.
So we're just going to table this and let the chips fall where they will.
It can be put on the agenda when the proper information comes forward. What holds that back?
What?
Your motion to table takes precedence over everything else, and there's no discussion about it. Once you made a motion to table, it takes precedence over everything else.
Is there a second?
I'll say.
Go ahead and reread it, please, and then call the vote.
Supervisor Alaska moved to table to a date uncertain, seconded by Supervisor Wolf. Supervisor Fisher?
No.
Chairman Merrick?
No.
Supervisor Bansky?
No.
Supervisor Alaska?
Yes.
Supervisor Wolf?
Yes.
Motion failed.
On with discussion. What would you folks like to do with this?
My belief about this is that the town of Waukesha should not end up being the bag holder at the end of the day on this in any way, shape, or form. I too think that the bill is outrageous. And I guess I would ask Attorney De La Mora to make a recommendation to us as to how this matter can be resolved without the town of Waukesha being exposed to the potential financial burden of that bill that I find outrageous.
You can authorize me to appear on behalf of the town and resist this, in which case I would expect that you will be compensating me for my services. You have to keep in mind that the work that we did was in direct response of the directive of the town when Mr. Morgan appeared and basically threatened, as I understood it, and as I believe the town understood it, to sue the town. And this was preceded by the recommendation that was made by the planner that is part of the land division that was being requested by Mr. Morgan on behalf of the estate, that there be a dedication of a portion of Milky Way Road. Mr. Morgan insisted that this was an ancient road and therefore not subject to the specific provisions of the town ordinances, which expressly indicate that when there is a division of land, that there should be accommodation made for future roadways. I was directed to do research. As I have reported, there was nothing specific that we found that supported Mr. Morgan's contention, other than his own assertions, which he is entitled to. And I advised the town accordingly. As a result of that, the town, after we conferred with the town engineer, agreed to proceed with the approval of the certified survey map that had relatively recently had just been submitted by Mr. Morgan in May. And the position taken by the town, which we recommended to avoid any conflict in light of the fact that there were no eminent development plans, was that the road just be noted, basically, and reserved, if you will, as the ordinance uses the language. And we did do the work. We did it in good faith in response to what the town had asked. And as anyone who has ever used legal services would know, sometimes when there are obscure points that are being researched, points that don't really have a whole lot of case law, it takes a considerable amount of time to do that. We submitted detailed invoices to this town board for that work. And as far as I know, this town board approved payment to our firm of that work. Now, sometime after the fact, there are assertions that this is unreasonable, that this is excessive. I am not going to dispute anyone's desire to assert their own opinion, but no basis has been indicated. We have not done anything inappropriate here, and for that reason, I have been resistant of your chairman's insistence that, well, if there's a problem, you fix it. As I told your chairman, we are a law firm that does work for you. We are not your insurer. And we have not in any way done anything inappropriate. So if the town wants to deal with this, they could either engage our firm or they can engage another firm, as the town has often done in meeting its legal needs, and that would be the other way to deal with it. I recommended that there be consultation with the insurance carrier, because in some cases, while they may not prosecute a collection matter, they may provide some coverage associated with attorney fees. I hope that.
I want to follow up with that. First of all, you didn't answer the question. The question was, how do you intend to handle this without financial burden to the town? Your answer was, you want to go to court and be paid for going to court for your outrageous billing on ancient roads that you came up with nothing on. You just told us you came up with nothing. You billed the town $2,300 for that information. Nobody is sometime after the fact disputing or saying that your fees are unreasonable. I've been saying it for a year. And I've been saying that that fee was unreasonable, and we knew it wasn't going to get paid. We knew that it was going to be a problem to collect it. $2,300 for ancient road research just wasn't gonna happen. And now you want us to engage a different law firm to handle the problem that you created.
Enough of the badgering.
There's no badgering going on, Mike. We've got a problem, the town of Waukesha is being threatened with litigation because our town attorney and his billing practices. That's not badgering, Mike. That's protecting the town of Waukesha.
I have a question,
Supervisor.
Attorney Dillamore. If, just assuming for a minute, we were to authorize you to proceed and represent the town in court on this matter, 2 questions. Do you have an estimate of what that would take in terms of time and expense for you or your law firm to do that? And can you give us an idea of what the likelihood of your success would be?
I would be happy to provide that to you, but I have not given consideration to that because I have been told that I don't really have any particular standing in this matter at this point. All I've been told is what you have heard your chairman say repeatedly. And I would basically urge him to recognize that I reject what he has said. I reject what you had said. But that's a difference of opinion.
That's fine, but leaving that aside, my question to you is, leaving that aside, you have a difference of opinion. You said one option that the town could pursue was to have you represented in this matter and go to court, right? So my questions are, assuming we were to do that, and maybe you haven't thought about it until now, but we need to make some kind of a decision. What would that cost the town to have you represent us? And what's the likelihood that you would be successful? That's a different question than whether you like people's opinions about this.
No, perhaps you didn't focus on what I said. I would have to look at it. I cannot give you a response now, tonight. I'll be happy to follow up.
You were served with papers and you didn't read them?
Of course I did.
Well, you just
And
said
I
you
also-
didn't look
and
at
I-
it. You said you need time to look at it. Now you have read it, so give us,
Mr. Chairman, I have no desire to engage in a confrontational conversation. I basically was served with these papers and I immediately sent you a copy of these documents and I asked that the clerk's office circulate those. As a matter of figure of speech, I didn't look into the matter. I didn't spend any time because I was in the midst of exchanges with you, which are of record, about your insistence with regards to a number of things. And I felt that it would be counterproductive because if I spent any time looking into the matter, you basically would say, but who authorized you to do that? And so I basically urged you to make a decision as to what should be done here, or to ask the board for a decision.
But I guess the place that I'm at, in fairness, and I desire not to argue, but you want us to make a decision, if in response to my question, you'd say, well, that's probably gonna cost the town another $2,500, and your likelihood of success is 20%, I'm not taking that deal. Because we may be out $2,300 now. I mean, I'm looking at this from a business perspective. I don't desire to argue with you, but how can we make a responsible decision on that as a board? I'm looking to get some kind of a handicapping on what we're dealing with. We've had all kinds of topics tonight where we've talked about risk management. I'm not looking at throwing good money after bad with not a likelihood of pretty good success. It's just that simple, Attorney Dillamore.
Well, it is simple, and it's even simpler when you consider that you have a party opponent sitting in the audience, and you're basically asking someone who's possibly your own attorney to tell you what the odds are of success. It doesn't make sense to have that kind of a dialogue in this kind of a setting. Moreover, as I've indicated to you previously, I would have to look into what these procedures are because I am not a probate court attorney.
When, Jamie, maybe you can answer this question. question. When this road issue first developed and the planner got involved, is there a MOU that was signed by the estate of June Kemper?
Yes, and I raised that question. The MOU was signed by Mr. Morgan in his capacity on May 5th of this year.
Do we have a
Excuse me, April
Do we have a
this
copy
year.
of the MOU?
Yes.
Yes, it's right here.
Can I, please? So the paragraph that says, "I, the undersigned, have been advised that pursuant to the Town of Waukesha Code, if the town attorney, town engineer, town planner, or any other town professional provides services to the town pursuant to my activities or my request, or at the request of the town, I shall be responsible for the fees incurred by the town. In addition, I have been advised that pursuant to the Waukesha Town Code, certain other fees, costs, and charges are my responsibility." And I see there's a signature on here that matches yours, Mr. Butler.
I don't deny that.
So I guess I'm not an attorney, but it sure seems like when I read that, and I guess I do have a question, there's still a doubt out there about the phrase pursuant to the Waukesha Town Code, what that,
Well, that's the whole gist of it, and let me just, if you give me a minute, I can maybe cut this short.
You gotta come on up to the microphone, please.
In a matter like this, there's no policy issues involved, it's what's called a ministerial task. And the job in examining a certified survey map is to assess whether it complies with United States laws, Wisconsin statutes, and town of Waukesha ordinances. If the map complies, there's really no decision, it's a ministerial matter, and signatures and seals are to be affixed. Your ordinances, which I would suggest that your attorney should be familiar with, specifically allow for reservation of the 33 feet adjoining a public way, or a dedication. There's a very large difference between those two words, and it has a great deal of financial significance, particularly to the landowner. What a dedication is suggesting is that in this particular matter, we should give to the town a third of an acre of land that's probably assessed at $80,000 an acre. There's no basis for it. A township is not a city. You operate under very different rules. A city is home rule, and they can do anything that's not prohibited. But a town is a subdivision of the state of Wisconsin and can only do what state statute specifically allows.
and isn't that, I don't mean to cut you off a little bit, but if I recall correctly, the initial time that you came in and made the, declaration that you intended to pursue a lawsuit if we followed the planner Dubler at the time, made a recommendation within the approval that you could do what you wanted, but you had to give up this third of an acre, and you insisted that that wasn't true. And we
Right,
went,
exactly.
there was some back and forth, and
Exactly.
ultimately.
The thing is, your attorney, if you want a dedication, your attorney has to point at a properly enacted ordinance that says, I have to dedicate that land. Otherwise, you utterly lack the authority to make that requirement. As a matter of fact, making that requirement when it does not have a basis in statute or an ordinance, amounts to extortion. That is what this process actually involves in the back of it, requiring something that the ordinances and the statutes do not require.
Right.
You're looking for extra,
And
and that's why you are in court. There's no lawsuit threatened. We're in court, you and we.
I
Okay.
understand that reality. I think the process that I'm trying to walk through is how we got to Attorney De La Mora Law Firm doing some research.
Because all these people wanted free land
I totally
that's not
understand,
allowed.
totally understand your position on that. I hear you.
You're about to hear the judges too, but go on.
Well, and maybe we will. My motion is to refer it to the insurance company and let the judge work it out.
That's fine.
Is there a second?
Hold on. Refer to the,
Insurance company. And what did you say, like the judge would do, is that what you said?
Sure. We'll find out whether it's a valid bill or not. The judge will make the determination. I think that's a great way to have that result.
Seconded by Supervisor Wolf. Roll call.
okay, Supervisor Bansky,
Yes.
Supervisor Wolf,
Yes.
Chairman Merrick,
No.
Supervisor Fisher,
No.
Supervisor Laska.
Yes.
Motion approved.
All right, moving on. Reports. Treasurer's report. That's you.
Oh, it's in front of the for your review.
Is there anything you want to, commentary you'd like to share with us? We on budget with everything?
Sure.
Okay. Any questions for Treasurer Salentine? I think we'll move on. 5, accounts payable, authorization of the payment of the bills. Is there anybody that would like to take any of these invoices separately?
Can I
Yes.
jump in? Yeah, I took the liberty to do 2 separate motions from this point forward whenever
Okay.
Rupert and Milky are set out.
Thank you.
And so I will read the first motion, if that's okay with the board.
Yes.
Yeah, unless they have objections with something else. The motion would be to approve the payment of the bills in the amount of $37,850.24. This is without the payment of the Rupert and Milky billing.
Anybody want to make that
Also move.
Second.
discussion? All in favor? Aye. Opposed? Motion carries. And secondly,
The second motion would be to approve the payment of the Rupert and Milky bill in the amount of $7,688.16 with Supervisor Fisher to abstain.
Also move.
second? All in favor? Aye. Opposed? Abstain?
Aye.
Motion carries. Motion for adjournment?
Motion. Second.
All in favor? Aye. Opposed? We are adjourned.
Yeah, I can have it tomorrow. Nice meeting you. Thanks for joining
us.
I'll take it back. Yep, I understand what you're saying. Didn't register right away. You may call just a second. Reading your letter.
So you're really high up there now?
Right.
Not really.